Hi, this is Kaushik Ranchod from the Ranchod Law Group, and welcome to our immigration show. Today, we're going to be talking about the J-1 Exceptional Hardship Waiver. We're continuing on this series here so you can learn more about what works. And we're going to be talking about mental hardship here for two different countries. And you can see how this might be something that may be similar to you or not. And if you haven't already, smash that like button. All right. Back to business. So, first of all, why do you need a J-1 Exceptional Hardship Waiver? Well, some of the reasons may include if you got U.S. government funding, you can utilize Form I-612 to apply for the Exceptional Hardship Waiver. If your country is on the skills list, you're eligible to apply for the Exceptional Hardship Waiver. If you are participating in medical training in the United States, you're eligible to apply for exceptional hardship waiver. Also, what's important to know is that you have to also meet other requirements. Of course, you have to have exceptional hardship to a qualifying relative. So who's considered a qualifying relative? Well, it would be a U.S. citizen spouse or lawful permanent resident spouse, or a U.S. citizen child or lawful permanent resident child. So if you meet those requirements, you may be able to file Form I-612 with what we like to do is prepare a very detailed legal brief outlining the exceptional hardship arguments to USCIS. Simultaneously, we also submit the an application to the Department of State. Now, let's dive into our example. So first of all, I'm going to talk about hardship in a specific case where the applicant was from the Dominican Republic. So in this situation, the U.S. citizen had emotional hardship, and we were able to talk about this emotional hardship and tie in the factor that she had a miscarriage, which contributed to the emotional hardship. So that was one very significant factor of emotional hardship. Also, there was an instance of horrific violence that occurred in the Dominican Republic, and so we were also able to discuss this as well. So this also adds on to the country conditions specifically as well. We always like to include the country conditions if it's applicable, and of course in the Dominican Republic it is. So we're talking about violent crime, we're talking about access to education, we're talking about access to health, and all of that, how that would directly relate to your case. We also like to talk about whether there's ties to the United States. So here we talked about how there was religious ties, there was family ties to the United States, which would cause exceptional hardship if she had to go to the Dominican Republic. In this application, we also included a psychological report which substantiated the emotional hardship. So this may be appropriate at times, and each case is different, so we'll look at the case and determine whether or not that's something that would pertain to you or not. So by tying all of these hardship factors together, we were able to file a successful case. There was one other point as well that we included. The couple was working to pay off debt, so in this situation we also included financial hardship. All right, I hope that was helpful. So let's move on to our next case study where there's a similar factor of mental hardship. However, this was for an applicant from Jordan. So you can see that the different types of hardship can work in different countries depending upon what your specific type of hardship here is. So in both of these situations, emotional hardship was a key factor where we were able to get the case approved. So if you've watched my other videos, you know that we have to prove exceptional hardship if the applicant and the spouse are separated, or if the U.S. citizen goes to the home country, which we did in this case. Now, in this case, the U.S. citizen had a history of mental health issues. So we were able to document those mental health issues and include that in the application to make the emotional hardship argument. One way we demonstrated that is by having to go to a country that she's unfamiliar with would exacerbate those mental health issues, and it'd be exacerbated as well if they were separated too. So you can see that both of these situations would have triggered the mental health issues, which was the argument that we made. We also argued that the client's spouse was financially dependent on our client as well, And so that was a form of exceptional hardship that could occur if they were separated because of that financial hardship too. And then finally, in this situation, we thoroughly documented the country conditions that would have adversely affected our client as well if they had to go back to Jordan as well. So we combined all of those arguments to create an exceptional hardship waiver. So you can see that these cases were similar in the point of mental health hardship. They had financial hardship, different types of financial hardship. The prior case, one was paying off debt, and the second case that we discussed, it was more about being reliant on the client. So you can see that you can have different types of hardship argued in different ways and different factual patterns that depend upon your unique situation. I want to thank you for taking the time out of your busy day to watch this video. I don't take that for granted. And I want to thank you for tuning in, for being an amazing person, by bettering yourself, by watching this video because you want to improve yourself, you want to improve your family. And make sure, if you haven't already, smash that like button, put a comment below, and subscribe if you want to keep on getting these videos. And bye for now.